16585 instead of Christina Lugo.
State versus Lugo.
Brittany Sakovich on behalf of Ms. Lugo, who's present in the box. It was set for a bond hearing, but it's going to be an admission to the violation of probation.
We can bring her over. Ms. Lugo, when you get to the podium, will you raise your right hand to be sworn, please? Ms. Lugo, is it true that you're wishing to admit to the violation of probation? Will you state your full name and date of birth, please?
Christina Lugo, 11/10/84.
One more time, I'm sorry.
Christina Lugo, 11/10/84.
I'm showing you a document that's titled Violation of Probation Community Control Plea. It's 2 pages. Page 2 has a signature. Is it your signature?
Yes.
Did you sign it after you read each sentence of both pages completely?
Yes.
Did you understand everything you read?
Yes.
Did you go over the entire document, every sentence with your lawyer?
Yes.
Did your lawyer explain all the rights you're giving up and answer all your questions?
Yes.
Satisfied with their representation? Has anyone forced you to enter this admission?
No.
Has anyone promised you anything other than what's on the plea document?
No.
Are you under the influence of any drugs or intoxicants?
No.
Are you taking any medication affecting your thinking?
No.
Do you know if you're not a U.S. citizen, you will be deported?
Yes.
Is it true that you were on probation for grand theft?
Yes.
Is it true that you violated your probation?
Yes.
And state, how was this done?
Sorry.
How was it done?
Yes, Your Honor. Violation of special condition of failure to pay restitution.
Okay. Is that true that you did not pay the restitution as ordered?
Yes.
I will find that that is a violation of probation, that it's a substantial willful violation of probation. And at this point, in CF 1516585, the court will adjudicate you guilty, revoke and terminate probation, send you to 46 days, Orange County Jail, credit for 46 days that you've served, impose all the statutory court cost fees, costs of prosecution, cost of defense, all the costs that were previously imposed, and they all need to be paid to the clerk within 2 years. You have 30 days in which to appeal the judgment and sentence. If you can't afford an attorney will be appointed to represent you. Any appeal must be in writing. Good luck to you.
Thank you.
Next, please, whoever's ready.
Your Honor, we can call Joseph Miller.
State versus Miller, that's CF 1610427.
Your Honor, Stephanie Fritchell on behalf of Mr. Miller. We did receive one of the evaluations. However, we are waiting for the second one. Dr. Mings had surgery and it has put him behind. If we can just reset this to get the second one, I anticipate both will be incompetent and conditional release.
State, anything further?
No, Your Honor.
2 weeks, is that about right?
Yes, Your Honor, and I hope so.
Well,
That should be fine.
we either need that or we need another doctor.
Yes, Your Honor, completely understand.
Set it for the June 29th, 9 a.m.
Yes, Your Honor.
Thank you.
Your Honor, next if we can call Paul McKay.
State versus McKay, that is
He's currently in
State
the courtroom.
versus, CF 1615099.
Your Honor, after speaking with the state has no objection to dismissing the violation of probation.
Is probation still going on?
Yes, Your Honor. He still has over a year of probation left, and he's going to complete his conditions.
And CF 1615099, court will dismiss the violation of probation. You need to report your probation within 72 hours. So let me say that clearer and differently. By Tuesday, next Tuesday at 4 p.m., you need to report back to probation.
Yes, ma'am.
Thank you.
Thank you, Your Honor.
Good luck. Give me a call if you have any issues, okay? State versus Avante. Will the attorneys approach? You may. Next case, please. Yes. Yes, sir.
On violation of probation.
Yes, sir.
Previously set for a hearing on the 22nd. I generated a motion to continue because I will be out of town at a CLE conference. Then this popped up on the calendar. So in conclusion, I'm going to ask to postpone this from the hearing that I had set for next week for the next docket or the next VOP time.
Sir, raise your right hand to be sworn.
I do.
State what's your final best plea offer. Okay, I'm going to pass the case. We'll call him or get his final best plea offer, please. Next, whoever's ready.
Your Honor, on behalf of the state, there's two cases, Janet Perez, there was a pro se motion to terminate probation, substituting of the tax attorney.
State versus Perez, that's CF145280, CF145647. Jeanette Perez. And state, are you having any objection?
Your Honor, I spoke to, in the case number 14, CF5647, I spoke to Ms. Carman in the case. She did have an objection, but just to the court's information, her objection was primarily based on the fact that she didn't get restitution, but to give court background, basically a set of golf clubs were stolen. She went and bought a replacement set, but then she recovered her set of golf clubs, so that's probably why the restitution was never ordered to actually recover the property. And then I spoke with Mr. Perez, Marcos Perez, in case number 14 CF5200B, and he had no objection. So, simply the court's discretion this time, I just want the court to know that's the victim's position. She's been fairly successful in probation. I know there's one violation, but I think she went to Phoenix South and seems to have successfully completed that. So, that's where we are. And so there's no balance as far as concerns for monetary.
And understanding all those facts, the court will grant your motion to terminate probation. Good luck to you on both cases. Thank you.
Thank you, Your Honor. Have a nice weekend.
You too. Next case, please.
Judge Richard Parker on behalf of Mr. Michael Anderson. He's present, approaching the podium at this time.
That's CF17406.
Mr. Anderson was sentenced on December 15th to a resisting an officer without violence. His 6-month date is today. I spoke with his probation officer, Officer Klingenberg, who had no objection to him terminating as long as he paid the remaining costs that he owed the court, which he did this week. I presented the receipt to the state attorney, who also has no objection.
That's correct, Your Honor. Without objection, granted.
Thank you.
Thank you. Good luck to you, sir.
Judge, I have 2 cases printing that I believe just were not canceled. We already did a notice of hearing for another date. They're Jarvis Harden. It's a competency status.
Jarvis Harden, State CF178450.
It should just be canceled. There was a notice of hearing sent out for July 27th.
July 27th. Is that right? July 27th, 9 a.m.
Same thing for Henry Parrish.
That's State versus Parish, CF179740. I show July 27th for status. Thank you. State versus Shane Wilson. Shane Wilson.
That's my case as well, Judge. The defendant filed a motion to come back and face the charges here. We got a letter back from the sheriff's office. They couldn't get him from state prison. He has another case in Lake County that he filed a Rule 3 on. That's set for evidentiary hearing on June 25th. I spoke to the sheriff's office yesterday. They can't get him until he goes back to state prison.
Is this in fact an arraignment as it states?
It is.
I'm going to appoint the public defender's office to represent Mr. Wilson, CF1614324, which I show is a possession of firearm by convicted felon.
We'll go ahead and enter a not guilty plea and waive the formal reading.
Thank you.
Thank you.
And I'll withdraw the capias. State versus Malat de Source, CF177298.
Mr. DeSource, we're waiting on the Creole interpreter.
Okay. Will it be ready to go today on one status or another?
The evaluation came back not competent to proceed. I've given it to the state. That's where we are.
Okay, thank you. State versus Darren Grissett, CF 1049052. Did you say a plea?
Yes.
You may. Thank you. Sir, will you raise your right hand to be sworn, please?
Yes, sir.
Sir, is it true that you're wishing to admit to the violation of probation? Will you state your full name and date of birth, please?
Adrian Ristic, date of birth 8/16/1979.
Showing you a document titled Violation of Probation Community Control Plea. It's 2 pages. Page 2 has a signature. Is it yours? Did you sign it after you read it completely? Did you understand everything you read? Did you go over the entire document, every sentence with your lawyer? Did your lawyer explain all the rights you're giving up by entering this admission? Did she answer all your questions? Are you satisfied with the representation? Has anyone forced you to admit to this violation of probation?
No.
Has anyone promised you anything other than what's stated in the plea form? Are you under the influence of any drugs or intoxicants? Are you taking any medication affecting your thinking? Do you know if you're not a U.S. citizen, you will be deported? Is it true that you were on probation at the time you were on probation for possession of cocaine?
Yes, ma'am.
Is it true you violated the probation? State, how was it violated? And what's the new charge? Is that true that you committed an assault with a deadly weapon while on probation?
Yeah.
All right. Then I will find that that is a Condition 5 violation. That's a willful and substantial violation of probation. The state, anything further? Defense, anything further? Sir, anything you wish to say?
No.
You understand it's going to result in your license being revoked for a period of 2 years, or period of a year, sorry, went back in time. Then CF 049052, court will revoke and terminate probation. Sentenced to 75 days, Orange County Jail, credit for 75 days served. Impose all the statutory required court cost fees, cost of prosecution, cost of defense, any other costs that were outstanding. All those amounts need to be paid. How do you want to pay them, sir? To be paid within 3 years. Good luck to you, sir. You have 30 days in which to appeal the judgment and sentence. If you can't afford an attorney, will be appointed to represent you. Thank you. State versus Dondre Jasper.
Your Honor, Stephanie Fritzl on behalf of Mr. Jasper. I've had communication with him. He's still on the bus on his way here, but he is coming today.
All right, thank you. Probably has about 30 more minutes.
Yes, Your Honor.
All right.
Can I go back upstairs or downstairs to the courtroom?
Yes, sir.
We can recall Benbrook. I spoke with Mr. Kelly.
State versus Benbrook.
We're approaching, Your Honor. Mr. Benbrook on the floor, please.
That's CF 141661.
No objection to the continuance. The state's offer is revoke and terminate 3 years in the Department of Corrections. He scores 18.3 months at the bottom.
Sir, do you understand that plea offer? Yes, I do. Do you understand today's the last day to accept that plea offer?
Yes, I do.
Okay. Do you understand that? I want you to have time with your attorney to make sure that you know that.
You understand that this is the last time I turned down a 3-year DOC offer?
Yes, I do.
Okay. Do you understand after this point, all that will be left is the hearing itself, and you won't be, again, at that point, there won't be any plea negotiation or anything further such as that. Do you understand that?
Yes, I do.
All right. And State, you said no objection to continuance?
That's correct.
Defense, how much time do you need?
3 weeks should be sufficient, Your Honor.
Set it for July 20th at 9 a.m. July 20th for the hearing. We won't do another status in between. We'll see you back on that time.
Thank you, Your Honor.
Thank you. Have a good weekend. State versus Sarah Lee Johnson, CF 115570.
I'm still trying to get an offer from the state.
Okay. It's 9 o'clock the day of, so this should have already been done. So please do it, and we'll pass it for a moment. Thank you.
Mr. Kelly's case as well, Judge. We're trying to.
Okay, thank you. Eduardo Jones, 11315.
Your Honor, Stephanie Fritzl on behalf of Mr. Jones. Last time we came here, Dr. Danzinger had to reschedule the evaluation as he was subpoenaed. The rescheduling, I don't think was properly communicated. If we can have one more reset to get it done.
July 20th at 9 a.m. if we can finish these up. These cases,
Yes, Your Honor.
will an attorney from the Public Defender's Office and an attorney from the State Attorney's Office approach? State versus Risquet Lopez, CF 1744005.
Morning, Judge Harris.
Morning.
Brandon Dark for the client. Your Honor, I believe the state has an announcement in this matter.
Your Honor, the Newell case was dismissed, the battery out of Miami. The other conditions, the technicals, had already been were completed, the impulse control class. The state would just be asking the court to dismiss the violations from the continuing investigation.
And is he present?
Your Honor, he's traveling up here from Miami. He's stuck in traffic. I've been in communication with him. I can wait if you'd like.
No. I'll dismiss the violation probation. However, he needs to report to probation by 4 p.m. on the 19th. That's next Tuesday.
Yes, ma'am.
I'm not certain now where that probation will be, but there's no objection to a travel permit in between. However, it might be that he needs to report back here first. All right? So you'll need to follow up with that.
I will make sure that he reports this afternoon when he gets here.
Thank you.
I'll be communicating with him shortly. Thank you so much, Judge Harris.
Thank you.
May I be excused?
You may.
Thank you.
State versus DeSoris, no Creole interpreter yet. Recalling State versus Dondre Jasper. Any information on Dondre Jasper?
Your Honor, last I heard from my secretary, he spoke with him, he was on the bus. He shouldn't be too far away at this point.
Okay, I'm going to issue a capus, but I'll withdraw it if we see him.
Yes, Your Honor.
State versus the sentencing case. The sentencing case. Oh, no, that was the sentencing case, wasn't it? Which one's that? Oh, that's what we're. Which case is it, I'm sorry? For Johnson? We need to handle Sarah Lee Johnson and then get all the participants back for Hall Sutherland, and we're ready to proceed.
I told this board to revoke, terminate 3 years DOC. She scores 18.3 months at the bottom.
We're all waiting on you, the entire courtroom, so let's do it. You said the Creole interpreter's on his way. We can also make contact with the attorney, with Mr. Fussell.
Yes, Judge, I'll text.
Thank you. Creole interpreter case, please. And Madam Creole interpreter, have you been sworn?
Yes.
Will you raise your right hand just in case?
Brittany Sakovich on behalf of Mr. DeSources. He's president approaching. If we could just wait till he gets up here.
And you may proceed.
Yes, I provided a copy of the evaluation to the state. Dr. Dorsonville has found him incompetent to proceed. So I don't believe that Mr. DeSource can represent himself or even go to a hearing at this point in time. That's where we are.
Thank you. State position?
The state is agreeing to the findings by Dr. Dorsonville and what he asked me for an additional evaluation.
Then, may I see it?
Oh wait, can I hand you the court paper? Yes. I like this one. I apologize.
I am reviewing the evaluation. Understanding that the state and the defense is stipulating to the report and the findings. And reviewing the factors that the doctor has used in determining his opinion, I am making a finding based on those factors, determining at this point that he is not competent to proceed. State Defense, how are we proceeding?
I believe that the placement in Holland is a conditional release. Doesn't meet the requirements for a state hospital.
And I will make that finding. I need an order for what the conditions are going to be agreed to by the parties, and if not, a status set for it. Thank you. Have a great day. Sir, stay in touch with your attorney. Thank you.
On his way.
And then we will start as soon as he arrives. Mr. Spencer, I don't think we have anything left on the docket. Do you need something?
No.
Okay. Perfect. State versus Hall, State versus Sutherland. Are we ready to proceed? State?
Yes, Your Honor.
Defense?
Yes, for Sutherland.
Yes, ma'am, on behalf of Mr. Hall.
State, any witnesses for sentencing?
Will the state be going first or the defense?
State.
May I have my client join me, Judge?
Of course. State, you may call your witness.
Your Honor, before we call our first witness, I'd like to address a couple of things. And I'd start with the fact that DJJ, the Department of Juvenile Justice, did not provide the PDR and a comprehensive evaluation within the time frame noted under Florida Statute 985.565. It clearly says that they were to provide that information within 48 hours of the hearing. I got that information late yesterday, and I understand that David Fussell got his reports around the same time. In addition, Judge, if you look
Are
at...
you wanting a continuance for that?
No, I don't want a continuance.
Okay, so...
I don't know if Mr. Fussell does, but I certainly don't want
Okay.
a continuance.
As to that defense, does anyone want a continuance because the PDR was not provided in the accurate, correct statutory time?
Yes, ma'am, and there's some errors in it, so I have an expert that I want to have a look over it. I've given it to her this morning. I'm not sure she's been able to finish it. I think we do a lot better.
Okay. Attorney's approach.
Because there's some inaccuracies.
State, you may call your first witness.
Your Honor, the first thing that I would like to do is read an impact statement from Rodrigo Meirelles. He is not here today. He is the second victim in the manslaughter case that was not killed, but was in fact attacked by these two defendants. Bad experience are lessons you take from life. The tragic incident keeps returning to my mind from time to time. Roger was my best friend. I don't hesitate to say that. Having him taken from me was something I don't wish on anyone. Since then, I realized there are bad people in the world. Since then, I realized we aren't safe all the time. I have realized how serious and fragile life is. I had a case with Roger, and we used to be lab partners. Since his death, I sat right next to an empty chair for the rest of the semester. I could not focus in class. It was painful to stare at that chair. I was not a happy person for a while. I had anger issues since Roger was killed. People felt sorry for me and treated me with pity, and I just hated that. For 1 year, I missed school days to go talk to attorneys and depositions, and I saw little advancement at that time on the case. I write this letter today after testifying in a jury trial where Jessie, Sutherland and Simeon Hall were both found guilty of manslaughter and battery. I am choosing not to attend the sentencing hearing today, but want to make sure the court, Roger's family, and both of the defendants are aware that I miss my friend Roger deeply. I miss all the good times we had. I am sad we didn't get the opportunity to make more memories together. I have found forgiveness in my heart for what the defendants did to me, but relating to Roger, I hope they both learn from this tragedy and that they grow into successful members of this society. Roger was a great person, and I am heartbroken that he was taken from this earth way too soon. The second individual we'd like to place on the stand is Chief Deal. He is the chief of police from the Winter Park Police Department. Chief Deal, I'd first like to thank you for attending today and bringing members of the Winter Park Police Department that investigated this case. Is there anything that you would like to say to the court, knowing everything that happened in this case, as what you think is an appropriate sentence for the death of Roger Trindade?
Yes, I'm here on behalf of the Winter Park Police Department and to share with you that I think that the Winter Park Police Department did a very thorough job investigating this case. Spent a lot of time, a lot of hours, a lot of people involved, and again, a very thorough case. And I think that the investigation shows that this was indeed an intentional and unprovoked act of violence that took the life of Roger. So, you know, as Rodrigo had mentioned in his impact statement, the defendants need to learn from their actions. There needs to be consequences for their actions. And you know, I would recommend that those consequences not include a juvenile option, that they need to, the age of these defendants they're almost adults, 17, and I truly believe that for them to learn and to be held accountable for their actions, that juvenile option should not apply. Thank you.
Thank you, Chief.
Yes.
Questions for by Mr. Sutherland's attorney?
None, Your Honor.
On behalf of Mr. Hall.
Chief, you followed the investigation as it occurred?
Yes, sir.
Who was the first person involved in this case that actually called the police department and agreed to meet with the investigators?
I'm sorry, could you repeat?
Who is the first person that called the investigation unit, your police department, and agreed to meet with the detectives in this case?
I cannot answer that.
Okay. And you said that defendants are 17. You believe my client's 17?
I believe that at one point they're 17. I'm not sure exact age right now. So.
Okay. I have nothing further going.
Thank you. Thank you, sir. Next.
The next person we'd call would be Adriana Trindade.
Can I read?
Absolutely.
Roger was our only son, a boy full of life, always with a smile on his face. He was born and grew up in a loving family and used to say that a simple gesture of affection could brighten a person's day. He was loving, polite, generous, always ready to read out to anyone in need. Moving to USA was a life experience for him, a unique opportunity to learn about the culture, history, and country. As his teacher in Winter Park High School stated, Roger was the American dream. He was determined to have a good education and had energy and passion to learn. Roger was a boy with full abilities that we are very proud of him. Bullying is an aggression that cannot be accepted in any way, anywhere around the world. Roger was murdered by the irresponsibility and the levity of many. We hope that the ones responsible receive the maximum applicable penalty. We hope that justice can send a strong messenger and clean to all violent and aggressive juveniles involved in this case. One cannot play with the lives of others. This kind of hostility to an innocent child is not acceptable and should be punished as law required. Sorry. And we have the last picture of Roger. Remember that.
Hold on 1 second, ma'am. On behalf of Mr. Sutherland, on behalf of Mr. Hall.
No, ma'am.
Thank you, ma'am. I'm going to step down. State, next witness.
Yes, Johnny Alderman, please. Johnny Alderman, please. Yes. Tell the judge your name, please.
Johnny Alderman,
And would you spell your last name for the record?
Alderman.
You are the local chief for the Department of Juvenile Justice for the Ninth Circuit, is that correct?
That is correct.
And the Ninth Circuit is Orange and Osceola County.
That is correct.
So you are also responsible for the predispositional reports and recommendations to this court, is that correct?
That is correct. I have an overall responsibility.
Now, there were 3 levels of commitment in the juvenile system, correct?
Yes, ma'am.
The highest level of commitment is a maximum commitment.
That is correct.
The mid-level commitment is a high-risk commitment.
Correct.
And the lowest level is a non-secure.
Yes, ma'am. And I may add that there is actually one more level.
Okay.
Minimum.
The one more level, they're not really locked up.
No.
Thank you. It's like daycare.
Day treatment.
Okay. Now, you recommended, the Department of Juvenile Justice recommended a high-risk commitment on Jessie Sutherland in this case, correct?
That is correct.
And are you aware that a high-risk commitment program, the average stay is 9 to 12 months?
It's more like 12 to 15.
All right.
It's the average length of stay.
Are you familiar with the DJJ website?
Yes, I am.
Are you aware that under residential services, high-risk residential, a youth who is sent to a high-risk residential commitment program by a judge will stay in the program from 9 to 12 months? Are you aware that your website says that?
I am not aware of the specific dates, but I will tell you, let me explain. Residential programs are actually performance-based. So if the child is not doing well, they can remain beyond that.
All right.
And I've rarely seen in my 18 years experience that youth get out within that time frame. They have to be doing exceptionally well.
It's rare when you see a youth get out in 9 months
From a high-risk program, in my experience.
All right. Are you familiar with Jose Martinez?
I cannot say that I'm familiar with that
Let me
individual.
help you with that. Here,
Objection, Judge.
Sustain.
I'll provide this to the defense.
Still sustain.
Thank you.
One approach?
Yes, Judge.
So I will be presenting these documents to the court for their review, which concerns several individuals who receive 9 months in a high-risk program. Now, your recommendation on Jessie Sutherland is the mid-range, and the high range.
That is correct.
Now, do you agree that killing someone is probably the worst thing someone can do?
I would agree, and it depends upon the circumstances surrounding that. Was it malicious? Was it intentional? Was it purposeful? Premeditated?
But still, taking someone's life is not something we see on a daily basis in the juvenile system.
No, we do not.
And that's very serious.
Serious and sad.
Very serious and sad. All right, I have no further questions of this witness at this time. Thank you.
Thank you. On behalf of Mr. Sutherland, any questions?
Yes.
Good morning, Mr. Alderman.
Good morning, Ms. Rodrigo.
It's my understanding that the Department of Juvenile Justice makes a recommendation based on a number of factors. Can you explain everything that was taken into consideration in this specific case for this recommendation?
Yes, first and foremost, we look directly at the offense and we look at the circumstances surrounding the offense, what had occurred. And during our assessment process, we perform a risk level assessment on the individuals. We have 4 different risk levels. We have low, we have moderate risk, we have a moderate high risk, and then we have a high risk. Those are factors that we use to determine, and it's not an exact science, but it's a very good predictor, and it determines the use level to re-offend. And Mr. Sutherland scored low, and that could have been based upon no history with the department, which he had no history with the department, family dynamics, protective factors, very involved family, things like that will go into that formula, and then we came up with a low risk for him.
Was the department also privy to the police reports and the factual allegations surrounding this case?
Yes, we get the initial arrest affidavit or probable cause warrant that would explain what happened.
And how long have these procedures, these assessment tools, and these reviews of other records been in place in the department?
Ever since the initial, I will say after the youth was arrested on the probable cause warrant.
Overall in the department, how long have these same methods been used?
I know that we introduced the Positive Assessment Change Tool, the PACT. That came online about 2005.
Okay, and in this specific case, the department's recommendation was high-risk residential treatment program?
Yes, it was.
And that was based on considering safety of the community and needs of my client?
Correct, and we also, we refer our youth out to an assessor, a psychologist, who will perform an evaluation on the youth and will make a determination, and it's only a recommendation, to determine what are the needs, how is it best to serve this youth, and what is also the risk to the community. We get recommendations back to, from our evaluators for kids to be treated in the community, and when needed, they will recommend that the youth may need a more severe intervention, such as a residential program.
Thank you. I have nothing further.
Thank you. On behalf of Mr. Hall.
Yes, ma'am. Your department also made a recommendation in reference to Mr. Hall?
Yes, sir, we did.
And can you tell me what your understanding of the facts of the case are as far as his involvement?
That they were engaged in altercation with Mr. Sutherland, with Mr. Roger Trindade, and because of an altercation that they were engaged in, there was the death of Mr. Trindade.
You know who hit and killed Mr. Trindade?
From my understanding, they both had an equal part, but from recent discussions with statements that it was Mr. Sutherland that actually hit the young man.
Did you know that when you made the recommendation for the?
Yes, sir, we did.
And you recommended for Mr. Sutherland that he be allowed to go to a youth program, correct?
Correct.
Have you ever seen Mr. Hall prior to today?
No, I have not. Only on media and our records that we have.
And someone did a psychological assessment for y'all, a person that's out of Bradenton?
Yes, we did, Mr. Dale Thompson.
And is he based here?
He is based in, but he has evaluators here.
And did he do the evaluation here?
Yes, he did, with Mr. Hall in the county jail.
He himself did it?
No, it was one of his assessors.
Okay. Was I given notice that they were going to assess my client?
I don't believe you were. I'm not exactly sure of that.
Was I given notice that we could have a staffing?
No, sir, you weren't.
Did you get any input from me?
We did not have a staffing for Mr. Sutherland. There was an attempt to do one, but it did not occur.
And that was on a day where someone from your office called me and told me it was about to begin?
That was a commitment manager. I believe that may have been on May 31st.
Okay. And they were at the jail at the time?
They were.
And they did not give me an advance notice in writing or by call, correct?
No, sir, they did not.
They called me and said, we need you to come to jail right now. We're about to do this.
Mm-hmm. That is correct.
And there was no way I could call them back even?
No, sir, not that I'm aware of.
So the person, and this is a hard case to describe. It's a big tragedy. There's a young man dead.
Absolutely.
Family deprived of him. I don't think anybody would allege that either one of these gentlemen intended to kill him. And The way I look at your evaluation is, however, that the gentleman that actually struck the bull and killed him, actually was dead when he hit the ground practically, got a much lower recommendation than my client did.
That is correct.
State any other questions?
Yes. In fact, Mr. Alderman, DJJ decided not to do a staffing on Simeon Hall, correct?
Yes.
Okay. You did, however, do a staffing on Jessie Sutherland.
That is correct.
And a staffing is where the families of the defendants get to appear and provide mitigation to you.
The family of the offender.
Of the offender, correct.
Correct.
And the state was called on Tuesday saying, where are you? We're doing a staffing right now, correct?
That is correct.
So I didn't get prior notice of that either.
That is correct.
You then reset it when I objected to any type of staffing.
The commitment manager reset the staffing.
Okay.
Because we wanted all parties present.
Okay. But all parties weren't present because Orange County Public Schools was not present.
That is correct.
They typically are.
They typically are, but during the summer times, participation is rare.
I understand. So typically in a staffing, Orange County Public Schools is there, and the state is notified in advance and given an opportunity to provide a victim impact statement. None of that was done with Jessie Sutherland, correct?
Correct.
As far as Simeon Hall, you did not even bother to do a staffing, and so clearly we weren't notified of that either.
Right, and there were circumstances surrounding why Mr. Hall was not staffed.
Okay.
Anything further for this witness? Thank you, sir. You may step down. State next witness.
Your Honor, I believe Mr. Trindade would like to address the court.
Good morning.
Mr. Trindade, would you like to say something to the judge?
I do, yes.
And can you please speak up so you can
Yes,
be heard?
yes. So first of all, I'd like to talk about the motivation of this crime. Because every crime has to have a motivation. This doesn't happen just out of the blue. No one's capable of explaining what was the motivation that caused the death of my son. Was it love? Was my son after one of their girlfriends or something? No. Then we were told they were boys being boys. So is it like growing up is like that? Is it educational? So what was the motivation? There is none. Then we were told they were strangers. Why? They're strangers. Why? Because they were different? They were speaking a foreign language or something? Is that enough to commit a crime like that? Were they being brave by committing that aggression on my son and his friend, acting like a pre-gang? Is that acceptable? Is that they were just children? Look at the size of them. They were twice the size of my son. How can they claim being children now? That's the first part. Why? I can only say hate. They hated them because they were strangers. And they come up with absurd force against a tiny, skinny child that had no fighting skills. The skills were on his brain. He was educated to be a good citizen, to be a good husband, future husband, a good father that he would be. Were they brave? No, they were cowards. Cowards to attack a little child, half of his size. And it was not only the two of them, it was over 15. It was a group of people, so my son could not do anything. He just couldn't defend himself. This is the picture I have in my mind. There's no motivation. It's a brutal attack with pure hate and anger. The second part is, my son is gone, there's nothing that can bring him back. Even if you could punish all mankind, he would not be back. So what's at stake now? How should you punish them? Truly, to us, it's not going to change anything. So I think this is about how much you want to protect this community and this society here from them. Because they did that with no motivation, with hate, only hate on their hearts. That's all they had. And now it's up to the system to decide how much or how long you want to protect the other kids that are still here. How long you want to protect them from the hate of others. It's your decision. That's what I have to say.
Thank you.
Thank you.
On behalf of Mr. Sutherland? No, Judge. On behalf of Mr. Hall?
No, ma'am.
Thank you, sir. You may step down. Next witness.
The state has no further witnesses. We will be presenting during argument some of the other documents.
Thank you. On behalf of Mr. Sutherland, witnesses.
We call Dr. Jacqueline Olander to the stand.
Morning.
Before we begin, I approached the state about stipulating to Dr. Olander's qualifications to give an opinion in this matter, and the state did not respond. So I'm not certain at this time if the state is willing to stipulate to her qualifications.
Are you stipulating to her qualifications as an expert at this point?
Your Honor, I will stipulate to the fact that she has her PhD and that she is a licensed psychologist.
Okay. It sounds like no, so you'll proceed.
Good morning, doctor. Could you please state your name and spell it for the record?
Yes, my first name is Jacqueline. That is spelled Jacquuelyn, and last name is Olander, Olander.
What is your occupation?
I'm a licensed psychologist with a specialty in forensic neuropsychology.
And what does your education and training consist of?
I earned my bachelor's degree at University of Florida with a major in elementary education and a minor in psychology. I completed my master's at the University of Washington, 3 master programs in reading disabilities, guidance counseling, and school psychology. I spent 2 years as a Peace Corps volunteer out in South Pacific Ocean, teaching English as a second language. I returned to the United States, worked 16 years in the public school system as an elementary teacher, secondary teacher, guidance counselor, school psychologist. I created, designed, and was funded in the development of at-risk programs for students in the state of Washington. I returned to Florida after the University of Miami offered me a scholarship to obtain my doctorate in psychology. During my doctoral program, I worked for Dade County Schools as a psychologist for emotionally and behaviorally disturbed children. Then, after I completed my doctorate in psychology, which is a study of human behavior, I did additional work, practicum, with the University of Miami School of Medicine, followed up by a 2-year residency at Orlando Regional Hospital in the field of neuropsychology. Then I began working at Psychological Affiliates, and I've been there for about 20 years.
Do you continue taking education classes or receive any training throughout your practice?
Absolutely. And one of my specialties has become, of course, given that I'm a neuropsychologist, which is the study of brain functioning as it relates to human behavior, is the examination of adolescent brains as they compare to adult brains.
Do you belong to any professional groups or associations?
Yes, I belong to the American Psychological Association and the National Academy of Neuropsychology.
And have you ever been qualified to give opinions before in this circuit?
Oh, hundreds.
Hundreds of times?
Yes.
Would you be able to go ahead and start to explain the difference between the juvenile and the adult brain development?
In the last 20 years, there's been an abundance of science in that application of identifying the differences. And because of that, the United States Supreme Courts have made significant findings in the development and acceptance of the difference between the adolescent and the adult brain. If we think about it, the human brain develops somewhat as an onion. There's various layers on top of it. And the part of the human brain that is the last part to grow and develop is what we call the prefrontal lobe, or the front part of the brain. If we're comparing the brain to a computer, it's the operating system. So in other words, there could be other areas that are more intact, but if you don't have a sufficient operating system, the ability of the individual to effectively utilize them is significantly decreased. So not having that executive function system fully matured, it can have pervasive effects on the individual's functioning in many different ways, particularly in regards to decision making. Adolescents are much more impulsive and risk-taking because the part of the brain that is connected to impulse control and inhibition and self-control is not fully developed. So in the decisions making, they're more impulsive. They're more reckless. They are also much more dependent upon peer pressure because they don't have that internalized sense of self. So in other words, they're more prone to follow a leader versus relying upon their own internal fortitude in the decision making. That affects them. Also, they don't have that sense of autonomy that adults have. So in regards to decision making, impulse control, impulse and emotional regulation, they focus on the here and now. They have a deficient ability compared to adults to think about and understand the impact of current behaviors on future behaviors, as well as on other people too.
And in this specific case, you were retained to evaluate Mr. Sutherland, Jessie.
Yes.
And can you explain to the judge what your findings were and the processes you used through your evaluation?
It's interesting. When I did my evaluation, I had the benefit that I received the 2017 report from DJJ prior to my evaluation. Then I received the 2018 DJJ report, obviously, months after I completed my evaluation. And they're all very, very consistent. They're consistent in that both the 2017 and 2018 report found that Mr. Sutherland has a low risk for reoffending. I found the same results. And I also did psychological testing to look at the impact of his life history and on his what we call nature versus nurture, his genetic makeup in regards to his personality and psychological functioning, as well as life experiences. And what I found is that Jessie has what we call a passive dependent personality. Now, that's neither good nor bad, nor is it necessarily healthy or unhealthy. The primary difference is a person who's born with a dependent orientation has increased needs for social interactions, social affirmation, and social direction. These individuals who are healthy tend to be very popular. They have very good social skills. They tend to be successful in the media world. They tend to be more unhealthy, though, when their peer group is negative and they don't have the internal support to stand up to them, walk away, and then choose other friends or other means of social support. Now, the opposite of a dependent is an independent person. Now, that sounds like that's more desirable, and in some ways it is, but in some ways it's not. Healthy, independent people only need a few people in their lives for that pat on the back, that social support, and they're very satisfied. When they're in a large group of people, it can be draining on them. However, those people who are not healthy and that have a dependent personality, who are more out on the extreme, we call those antisocial. So in other words, I didn't find antisocial characteristics in Mr. Sutherland at all. And I also found him more passive than active. And that means that they're more dependent, again, on their environment for that stimulation and direction and guidance. They can make excellent followers, but they don't make good leaders.
And with your findings, based on his personality type, I know there were some records that you reviewed through the department that included a diagnosis, and that diagnosis was of post-traumatic stress disorder?
Yes, I found that in all three of the evaluation. Obviously, Jessie, from that finding and that diagnosis, has a strong moral conscience. And because of that, he has suffered to the point where he developed PTSD, which is what soldiers develop when they're in combat.
And what are the effects? How is Jessie internalizing this stress and this trauma?
Well, he demonstrated a sense of significant remorse and guilt. He has problems with sleeping. He's at risk for suicide. In fact, if you look at the 2017 report from DJJ to 2018, he has increased risk for suicide. And again, that's common for people with PTSD. It's interesting that in a recent study from soldiers returning to Afghanistan, more soldiers have died from suicide than on the battle.
And given your evaluation of Jessie and your review of the other evaluations and documents, how would you describe his role in this situation? Was he the leader?
No, not at all.
Was he, in your opinion, subject to peer pressure?
Yes, he reported, and again, that's consistent with the data in my evaluations as well as DJJ, that he was fearful of his co-defendant and that he was fearful of standing up to him because he had a reputation of making life difficult for other juveniles or peers in that setting if they don't go along and do what he wants them to do.
Now, given Jessie's personality type and all that you've learned about him, taking into consideration that protecting society is a primary concern, what is the best thing to do in this situation?
That's a very difficult question to answer. What I can tell you is that this was an aberration. He is not somebody of bad character in the sense of many other juveniles I've evaluated. And there's also concern about what we call deviant peer contagion. In other words, and I see that so often in the schools when they have these emotional behavior disturbed kids in a group. There's a group dynamic that develops in which people, for which people who are part of that group are socialized and reinforced when they engage in similar deviant behaviors. So it's important, I think, to take into account the impact of deviant peer contagion on a person who doesn't possess at this point in time deviant beliefs. In other words, they have pro-social beliefs.
And the final issue I want to touch on is Jessie's diagnosis of ADHD. How does that impact his developmental functioning?
As I testified earlier, there's a significant difference in that prefrontal lobe in regards to adolescents and adults. What research in neuroscience has also identified that individuals with a diagnosis of ADHD, their development, and this is separate from intelligence, is approximately 2 years behind that of an average adolescent. So in other words, if Jessie was, and he was 15 years old and approximately a month when this occurred, from a developmental perspective, he was actually functioning as a 13-year-old in regard to that prefrontal area of functioning.
Thank you, Doctor. At this time, I don't have any further questions.
On behalf of Mr. Hall.
No, ma'am.
On behalf of the state.
You are not a medical doctor.
No, not at all.
You are a licensed psychologist.
Absolutely, ma'am.
You have your PhD.
Yes, with 13 years of college.
You don't have a medical license.
Oh, no, ma'am, I didn't choose that route.
Now, in your career, is it fair to say that you typically evaluate juveniles?
No.
No. What percentage of your practice, as far as criminal cases, involves juveniles?
Oh, approximately maybe 50%.
So at least half of your practice involves juveniles.
Yes.
How many juveniles have you evaluated that have killed someone?
Probably one.
This one?
Absolutely.
Now, you indicated that...
Can I note that? That's evaluating them at the age of juveniles. Now, I've evaluated many other adults because they've come back for resentencing due to actions that occurred when they were juveniles.
Gotcha. But this is the first one.
Yes.
Thank you. Now, you indicated that juveniles do not have a fully developed brain.
Correct.
That's all juveniles.
Yes.
Not all juveniles kill someone. Is that fair?
True.
Now, you said he has ADHD.
Yes.
There are doctors that have ADHD?
Oh, absolutely. In fact, people with ADHD actually have been found to have higher IQs than people who do not have ADHD as adults.
Correct. And those doctors and those lawyers and those other productive citizens in society that have ADHD do not kill someone.
Oh, most don't. However, there's a larger increase of individuals who do engage in criminal behaviors that suffer from ADHD.
Now, you indicated that this was an aberration.
Yes.
It was an isolated incident.
Yes.
Are you aware that the defendant, Jessie Sutherland, had 15 disciplinary file reports when he was in school?
Yes, I know that he has quite a few of them.
Yes, for physical attacks.
Yes.
Bullying.
Yes.
Other serious misconduct.
Yes.
Insubordination.
Yes.
Let's see what else he has. Defiance.
Yes.
All right. So it is not isolated. He's had other bullying and fighting situations.
I wouldn't correlate the two of those as similar, although he has had behavior problems in school without a doubt. And I have engaged in many of those type of experiences within a school setting, which is different from this particular event.
Well, you're right. There is a big difference between his 15 disciplinary referrals and his fighting in school and his killing someone. Definitely a difference here. Now, in your report, you indicated that the officers saw no visible injuries to Roger Trindade on page 2. No visible injuries.
That was taken from the arrest information.
I understand. So you weren't aware that actually in the autopsy there was a lot of injury on the side of the face of Roger where he was punched by Jessie Sutherland. You were not aware of that?
I don't know if I was aware of that specific event, but I do know aware of the consequences of the punch.
Okay. So you do know that as a result of that punch, Jessie Sutherland tore Roger's vertebral artery. He bled to death internally and died.
Yes, I'm aware of that.
Now, you indicate in your report that Simeon Hall spit on Roger when he was down, correct?
We have to review.
Yes, yes. I'll show you exactly where. On page 1, at the bottom, you say, Simeon Hall threw the first punch, and Simeon has been known, this is according to what Jessie told you, and that Simeon is known to have drugs, and you also indicate after Jessie Sutherland punched the smaller kid and was lying on the ground, Hall said he bent down and spit on Roger's face. Do you see that?
That was taken from the police records.
Anywhere in there do you say that Jessie Sutherland spit on Roger after he knocked him out?
No, it doesn't say that in this right.
So you weren't aware of that then?
I would have to go back and review the records when I wrote the report.
Are you aware that during the trial there was a video that actually showed Jessie Sutherland, Simeon Hall, and their squad of about 7 or 8 other juveniles celebrating the knockout punch that Jessie Sutherland delivered to Roger? Are you aware of that?
No, I'm not aware of the video.
Okay. Now, are you aware that Jessie Sutherland was actually the person who first arrived on the scene during this attack with his bicycle? Are you aware of that?
Yes.
Are you aware that he is the first one to start any type of physical contact?
Yes.
So you knew then that he was the one that gave the first push to Rodrigo, the boy who lived?
Yes.
Okay. And then once his buddy Simeon arrived and hit Rodrigo, he then killed Roger.
Yes.
Now, in your report on page 3, you indicate that this was a homicide, negligent manslaughter, killing a human other. Do you see that?
That's what was what I placed in due to the review of the records.
Okay, so you had no idea that that is not what the charge was?
No, that's what when I review records, those are not my words. I'm just summarizing the words from the records I reviewed.
All right. So if you knew that Jessie Sutherland was actually charged with an intentional act as opposed to negligence that resulted in Roger's death, that wouldn't have made a difference to you, or would it?
Again, this information was a summary of the record from the Department of Juvenile Justice. It wasn't my statement of the charge.
So you didn't consider that?
I considered that he hits a child, and that child died from the result of that blow.
Okay. And so you understood it was an intentional act, not negligence?
It was an intentional hit on his part that killed the child.
Right, which resulted in his death.
Yes.
So it was not a negligent manslaughter, it was an intentional act that killed him.
Yes, that's what he was charged and found guilty of.
Okay. Now, Now, you say his personality is passive.
Yes.
Correct?
Yes.
Would you agree that his actions that night were not passive?
No, but passive when it comes to personality description refers to whether or not they take on a more of a following role versus a leadership role. It doesn't mean that they can't be very active in their behavior, but it's a different use of the term passive.
Okay, so can you explain to me how you classify someone as passive when they are the one who is the first one there, is the first one to start the physical confrontation, and then not only kills Roger, but then turns back to Rodrigo and knocks him down and tells him to stay down? Can you explain to me how that is passive?
Okay. I guess a good description would be, and again, this is a generalization, is that some of our best soldiers are passive in their nature because they are great at following leadership. They're great in following commands. They're great in following a plan of action. They don't really take on the leadership role in developing that course of action, but they can implement that program.
Okay.
That's how it's used in personality descriptions.
All right. So how do you follow someone when you're the first one there?
Doesn't mean that that was the first step in this whole process that occurred.
I have nothing further.
Thank you. Any redirect on behalf of Mr. Sutherland?
Nothing, Judge.
Anything on behalf of Mr. Hall?
No, ma'am.
Thank you, Doctor.
You're welcome.
Next witness on behalf of Mr. Sutherland.
Judge, I don't have any additional witnesses today.
I'm going to go ahead and take a 10-minute recess, so we'll be in recess until 10:45.
May I run downstairs real quick?
Yes. And Mr. Fussell, you may call your first witness.
Can we call Dr. Jana?
Good morning.
Morning.
Good morning, Dr. Janner.
Good morning.
Would you state your name for the record, please?
Amanda Janner, Janner.
And where is your office located?
Psychological affiliates in Winter Park.
And how long tell us a little bit about your educational background, please.
I have a Bachelor of Science in Psychology from the University of Florida. I stayed on there to earn a Master of Science in Exercise and Sports Science. Went on to Florida Tech to get a master's on the way to my doctorate.
Okay. And where did you get your doctorate at?
Florida Tech.
And what year did you get that?
That was in 2006.
Okay. And are you a licensed psychologist in the state of Florida?
Yes, I am.
What year did you receive that licensing?
2007.
Okay. And how long have you been here in the Central Florida area practicing your practice?
Since 2007.
And do you evaluate and interview youths involved in crime?
Yes, I do.
What else do you do in your practice?
I also practice in family law.
And how many youth have you interviewed and evaluated, approximately?
Several hundred.
Okay. And some of those have been in criminal cases where they were the defendant?
Yes, they were.
Did you interview, or were you retained to interview and evaluate Mr. Hall?
Yes, I was.
And who did you interview in relation to your evaluation?
I interviewed his mother, Julie Hall, as well as Mr. Hall himself.
And did you review records?
Yes, I did.
And did that consist of the affidavit and some of the police reports in the case?
Yes.
Now, when you met with Mr. Hall, did you do any testing on him?
Yes, I did.
Can you tell us what tests you conducted?
Well, I did the Milan Adolescent Clinical Inventory, which is a general personality measure for adolescents, as well as the JESNIS. And in addition, Ms. Hall completed the a behavior rating scale on Mr. Hall's behalf.
So that was Mrs. Hall did that?
Yes.
Let's tell you tell us what Mrs. Hall's evaluation of her son was, if you could.
Well, she gave a valid profile, which means that she responded consistently and did not either over-report or under-report symptoms. And all of her responses and subscales were within normal limits. They were all within the average range. So she did not report any significant emotional or behavioral symptoms for Mr. Hall.
Okay. Now, did you also test Simeon Hall?
Yes, I did.
And can you tell me what tests you gave and what those tests revealed?
Well, for him, he, as I said, we shorten it to acronyms, the MACI, the Milan Adolescent Clinical Inventory, and that revealed some significant anxiety and depression, as well as more characterological submissiveness. And of note, on the low side were lack of conformity to rules and taking on strong leadership positions. So
I'm sorry, I missed that last sentence.
What was on the low side was the lack of conformity to rules, so he is rule-abiding, and
Leadership?
Leadership.
And he's low on that also?
He's low on that, yes.
And that, I'm sorry, when you say he's low on that, what does that mean?
Well, it was barely
elevated. It was, if you're looking at
It's the opposite of leadership, not.
Correct.
Okay, thank you.
Now, did you receive a report from DJJ last night?
First thing this morning.
Okay. And it was sent to you about 10 o'clock last night?
Yes, sir.
Did you look at what they did?
Yes, I did.
And do you have any opinion about the tests that they gave Mr. Hall?
Well, one of the tests was the same as the one that I had administered, the Jesness, with identical results. Some of the other measures I didn't believe were applicable in terms of vocational interest, and there were a couple of face-valid measures that had no validity scales embedded in them. And for social science, we like to have validity markers as well as the clinical data, and those were lacking.
There were tests that did not have validity markers?
Correct.
And are those tests currently advised to be given to youth in these situations?
It's of minimal assistance in the assessment process.
Do you have a particular author or book that you review to see what testing you should perform on individuals like this?
I do.
Did you bring that book with you?
I did.
Are the tests that DJJ ran on my client, are they in there as advisable?
No.
What is your opinion regarding Mr. Hall's depression?
It's significant, and I believe that it is progressing. Ms. Hall provided me consent to receive records from Adhd Behavioral Services that was working with Mr. Hall prior to his incarceration, and they had initially diagnosed him with an adjustment disorder. And now I believe he meets criteria for a major depressive disorder, which would be, a significant decline in overall functioning.
So the adjustment disorder is an indicator of depression, just not to the extent he's in now.
Well, what an adjustment disorder is saying that there is a marked stressor that has caused difficulty in coping. But I think that it has progressed for Mr. Hall to a level that is more of a depressive episode.
And he is on Xanax, or a
generic version.
Generic version?
Yes.
And is that for depression?
No, it's not.
Okay, what is it for?
It's for anxiety. It is one of the more fast-acting. So, for example, if you were having a panic attack, you would take a Xanax, and it would help reduce those symptoms. Whereas with depression, what you were looking for is more along the class of drugs known as selective serotonin reuptake inhibitors. While those take a little bit longer to take effect, they are more effective with those depressive symptoms.
And when someone is first prescribed a serotonin reuptake inhibitor, they have to be on it a few days before it even takes considerable effect, doesn't it?
A few weeks.
A few weeks, okay. What did you know that he has been convicted of manslaughter?
Yes.
Is your understanding that he did not hit the deceased person?
Correct.
And that he had another incident where he battered a young man after taking his monitor off. Yes. They got in a fight. And had one incident where he was smoking pot while he was on the monitor at home.
Yes.
Now, what's his relationship with his father?
Strained at best.
Are you aware of a battery incident that he and his father had?
Yes, I am.
Okay. Can you describe how that was presented to you? Did Mom tell you about it?
Yes.
What did she tell you?
She told me about an incident where the father came over. He was being very aggressive, Mr. Hall was trying to keep him out of the home after he had, tried to leave the situation, was holding the door so that his father couldn't come in. His father forced his way in, and an altercation took place at that point.
Did you understand that the father's a fairly large individual?
That's what I hear.
And did you understand he pinned him on the couch?
To the point where he was almost choking.
Was he arrested for that?
Was
the father domestic violence?
Yes, and the charges were dropped.
Did you talk to Simeon about that?
Yes.
And did he kind of confirm the same thing the mom said?
Yes.
And did the mom say she saw this?
Yes.
Did Mrs. Hall, Julie Hall, tell you anything about Simeon's relationship with his father while they were married?
I got the impression that it was good, that even post-divorce they had an amicable co-parenting. She and he had an amicable co-parenting relationship, and things went well with the children.
Was there a time where he became real serious with someone else where that relationship deteriorated?
Yes.
And back when everything was going good, would he come by and pick Simeon up and take him to movies or take him fishing, take him on events?
Sure.
Once the relationship started falling apart, did he absence himself from Simeon's life?
Yes.
Now, early on, I think while Simeon was still on home confinement, Simeon had a birthday?
Yes.
And there was a birthday party?
Yes.
And the father didn't come to it?
Correct.
What are the other than depression, what are the other testing or thoughts that you have about Simeon that you think may help the court in making its decision about sentencing him?
Well, he is a bit naive in some ways, passive. He's described as may not fully understand, the consequences of his actions.
Did he tell you that he didn't commit manslaughter?
Yes.
Is he having a hard time understanding the issue of principle versus being the direct person that committed the manslaughter?
I think so, based on the language that he used with me.
Okay. He does understand that he was involved in a fight which led to someone's death.
Yes.
And does he express any remorse for that?
Yes, he does.
The Kct Overview Report, what is that? Kct Overview Report?
I have not used it personally, but it's my understanding that it is looking at some of the same areas that I looked at using the Savory. Okay. In terms of youthful risk assessment. And one thing that both Dr. Grisso and the Savory point out is that, with adolescence, there is change that continues to occur over time, so it's not the same as assessing risk in adults.
Are you aware that Simeon received discipline from the school prior to this incident occurring?
Yes.
Are you aware that he has been in some scuffles or fights?
Yes.
Knowing that he's been in scuffles and fights, that he was involved in this incident where Ms. Trindade died, and knowing that while he was on pretrial relief, he took his monitor off and got in a fight with another kid. How's that impact the evaluation that you gave him?
As adults, we think about depression as being, sad. And in adolescence, it manifests more in irritability. So that can just be a manifestation of that depressive symptomatology.
Did you hear what Dr. Oleander said about the delay in development of the prefrontal cortex?
Yes.
Do you agree with her that the same things that she said about Mr. Jessie Sutherland also apply to Simeon?
Yes, the brain doesn't stop developing until 25 or so.
What do you think being incarcerated 24 hours a day is doing to my client?
I think it's exacerbating his depression.
Okay. Did you read the psychological report and the predisposition report that I sent you last night?
Yes.
And did
Hurriedly.
and did you reach any conclusion about his educational effort and his ability to function at an educational level for a 16-year-old?
Well, what we find is that IQ scores can be deflated with depression. Was one of the pieces in the intellectual assessment involves processing speed, and that is actually one of the symptoms of depression is psychomotor retardation, which is like a general slowing, and so he scored actually very low on the processing speed portion, and I think were he receiving the right treatment and potentially medication, because I'm not a medical doctor either, that he would score significantly higher than what we have here.
Are there any other skills that he tested low on that is not functioning at a normal level?
I would have to refresh my memory, if I may.
Did you do that, Your Honor?
Any objection, State?
No.
I apologize, Your Honor. I just got this morning. Also, in the area of concentration, his working memory was low as well, which can, again, be affected by mood.
Anything else?
Those were the main things that stood out.
What's your recommendation? You know what the adult prison system's like to some extent,
Yes.
right? You've interviewed people that went to adult prison?
Yes.
And you know what the juvenile system's like, correct?
Yes.
Which system would be best to work on Simeon Hall becoming an active member of society?
I think the juvenile system would be better suited.
And you heard, I think, earlier the description that there is there's a standard above high, there's high, then there's medium, then there's low. I would suspect that you would recommend either high or the one above that for him?
Well, I think a level at which he could receive the proper mental health treatment.
Okay. Do you think with the proper mental health treatment and some working on these issues that he can function in society without being violent towards others?
Yes. He has a number of protective factors that would be supportive of him moving in a different direction.
What are those protective factors?
Strong family support. He cares about his education. He cares about his future.
Is there anything else that you would like to tell the court?
I don't believe so.
No, I'll send it with us.
Thank you. State?
You didn't, you didn't do a report in this case?
Correct.
So the state hasn't had an opportunity to review anything, any reports or anything prior to your testimony here today?
Correct.
In fact, when did you evaluate Simeon Hall?
Wednesday.
Just this past Wednesday. Okay. And you met with him for how long?
About an hour and a half.
Okay. And again, as you indicated, you are not a doctor.
Correct.
Now, are you with the same psychology group as the last psychologist?
I am.
So you're both with the same group?
Right.
Okay. You work together?
We're independent practitioners.
Oh,
I mean,
gotcha.
we technically work together, but we're independent practitioners, as in, if she wanted to share information with me, we would still need the same release of information to be HIPAA compliant.
Gotcha. Now, you said that Simeon Hall is under anxiety.
Yes.
Is it fair to say that most people facing manslaughter where someone was killed might be a little anxious?
Sure.
Now, you say he's a rule follower.
Yes.
But you're aware that in school he wasn't a rule follower.
Yes.
Because he fought. Did you know that?
Yes.
He disrespected authority in school.
Yes.
He physically attacked someone.
Yes.
You're aware of that. You're aware that he bullied someone?
I'm not aware of any bullying.
Okay, so you're not aware of all the school records.
Right, I don't have any school records.
But you do know that he got in trouble in school
Yes.
for acting out, fighting, harassing, disrespect, physical attack, things along those lines.
Yes.
And that was prior to the death of Roger in this case.
Yes.
Now, you indicated that he has strong family support.
Yes.
But does he? With his father?
Not with his father.
Okay, so when you're talking about strong family support, you're saying his mother?
Mother and siblings, yes.
Okay. Now, you had indicated that you don't agree with everything that DJJ said in their comprehensive evaluation, correct?
Yes.
In fact, you differ in a number of ways.
Yes.
You indicated that some of the measures that they did you felt were not applicable.
Yes.
Are you aware that if the judge decides to sentence Simeon Hall as an adult, that in all likelihood he will be in a facility with people under the age of 21 or younger?
I was not.
Thank you.
Thank you. On behalf of Mr. Sutherland? Anything further from this witness?
No, ma'am.
Thank you. On behalf of Mr. Hall, next witness?
No, ma'am.
I have reviewed and received a copy of the PDR, the PSI, and the amended that was emailed to me last night after 5. I have read all of that. State, it's my understanding you also have received all those documents. Is that right?
I received the comprehensive evaluations, yes, and I've received the PDRs, yes. And when you're saying you received the addendum, are you talking about the one-page recommendation?
Yes.
Yes, I have received.
On behalf of Mr. Sutherland, have you received all of those?
Yes, ma'am.
On behalf of Mr. Hall?
Yes, ma'am.
From the state, any corrections or additions to them, other than what's been stated?
Okay. Would you like me, at this point, Would you like me to point out some discrepancies I see in the reports, or would you prefer that I wait to my summation?
You can use that for summation if you want, yes.
Your Honor, there is one correction. In terms of the memorandum submitted both on Mr. Hall and Mr. Sutherland originally, the ones you would have received via email, we did, at the last minute, when we're trying to e-file it, realize that we had a case number wrong on that. It was hand-corrected by the attorney who, on behalf of me, e-filed it. So it incorrectly said CF 2017-13416. It was corrected to reflect 13461. So that was the only change or addition to that. I wanted the court to be aware of that. On both of those cases, the case number was correct.
Thank you. State, what I'm asking for now is any corrections or inaccuracies, and then I can handle any arguments afterwards.
Correct. No, Judge.
All right, thank you. On behalf of Mr. Sutherland.
No, Judge.
On behalf of Mr. Hall.
Yes, sir. Yes, ma'am. I'd ask that the DJJ Standard Comprehensive Evaluation Psychological Add-on, which is actually a lengthy document, that it be stricken and removed from the record because we weren't notified that they were going to do an evaluation. We weren't notified that they were going to do a staffing until the day they were going to do it. And they were at the jail and told me I should come there then. I had no prior notice of it. They ended up not doing a staffing, but they did do the psychological evaluation and they interviewed my client. And that's what's in the DJJ document. I know you can't strike it from your mind totally, but I'd ask you to try to do that and strike it from the record.
Then I'm going to deny that request. Any corrections, inaccuracies?
Well, for example, when may I sit for just a second, Your Honor?
You may.
Judge, if I may?
You may.
I can actually speak to some of the inaccuracies, which I was going to discuss in my summation, on Simeon Hall's PDR.
Yes.
If you would like. First of all, if you look at the narrative under where they talk about manslaughter, number one, they refer to it as negligent manslaughter. Number two, in their narration, they give facts that have absolutely no relevance to the manslaughter case. They talk about something on Kct Way that occurred on 12/6 of 2006. So that is completely incorrect, and all of the information under that narrative is in fact wrong. On page 2, if you look at the charges, on the second case, they say the state filed an aggravated battery against Simeon Hall for the second offense, when in fact we did not. We never filed an aggravated battery. We filed a tampering with evidence and a felony battery. The defendant pled to a simple battery because as the case progressed, we learned we could not prove a felony battery. We could only prove a simple battery. So they're wrong again there. And as far, Judge, one more thing, as far as Jessie Sutherland's predispositional report, DJJ is also incorrect when they talk on page 2 of 7, when they give the narrative for the manslaughter case. The facts that they relied on in their report says there was a physical altercation among a group of juveniles with a victim left unresponsive, that he wasn't breathing. Then they also indicate that he suffered a brain aneurysm, all of which is incorrect. So that's incorrect on page 2 of their own document that they rely on when they make the recommendation. They also, on the 5th page, when they recommend what sanctions Jessie Sutherland should receive? They say alternative sanctions, which is pretrial diversion for killing someone. They then change it, like last night, to the mid-level high-risk commitment program in juvenile. So I wanted to point that out to the court. On Simeon Hall's case, they also recommend in their report, DJJ recommends commitment for Simeon Hall in their PDR, but they changed it late last night, and they recommend adult sanctions. So I point all those things out to the court.
On behalf of Mr. Hall, any corrections?
She covered them for me, Your Honor.
Thank you. Arguments state.
Yes, Your Honor. First of all, before I get into arguments, I would like to present to the court a copy. This has already been provided to the defense on a prior date, a copy of Rodrigo Meirelles' statement.
Thank you.
I'd also point out to the court that before coming in here today, I pulled a number of cases where juveniles did receive.
I object at this point, Judge. I
Attorney's
anticipate this is going to involve other juveniles.
Attorney's approach. And state you may proceed.
Your Honor, in this case, as the court is well aware, you have several possible sentences that you can impose in this case. The legislature has set out the sentencing guidelines. The purpose of the sentencing guidelines is to guide judges like yourself on an appropriate sentence given a crime that was committed in someone's history. In this particular case, if these defendants are sentenced according to the sentencing guidelines, which again the legislature has put there to give guidance to judges, Jessie Sutherland would be facing a low-end guideline sentence of 114.3 months in the Department of Corrections to a maximum of 17 years in the Department of Corrections. Simeon Hall would be facing a minimum of 128.48 months in the Department of Corrections to a maximum of 23 years in the Department of Corrections. Now, the court can always not follow that guideline and depart downward if you in fact find lawful reasons to do so. So you have the option to sentence them within the guidelines, the option to downward depart if you feel that's appropriate. The next option you have is the youthful offender option, which limits your ability to control these two defendants for 6 years, a maximum of 4 years in prison, followed by 2 years of probation or any combination thereof. That is your third option. The last and most lenient option is juvenile sanctions. If you impose juvenile sanctions, as DJJ is recommending as to Jessie Sutherland, you would lose jurisdiction at age 19, potentially. If he was committed to the the high-risk commitment program, which is not the most severe commitment program, it is the mid-range commitment program. Based on DJJ's own website, when juveniles get that sentence, they are being released from anywhere from 9 to 12 months. If Jessie Sutherland was given by this court the most lenient sentence, then chances are he too would be released somewhere between 9 and 12 months. Then you could potentially follow that up with probation until his 19th birthday. Both of these juveniles are almost 17. They will be 17 years old in the next couple of months. In fact, they're 10 days apart in age. What I want to do first is talk about why the state feels that juvenile sanctions are absolutely not appropriate in this case. Number one, Roger Trindade is dead. They killed Roger Trindade. Roger Trindade is not here to tell the court what he thinks should happen in this case. Again, the court would only be able to keep them on post-commitment probation once they got out till their 19th birthday. So I guess the question before the court is, do you think that 9 months is sufficient for punishment for the death of an individual? The state's position, again, it is not appropriate. Let's talk further about DJJ's recommendation to the court. First of all, if you look at both of these defendants, both about the same age, neither one had any criminal record before this incident. Okay? DJJ was never involved with either of them. It is Hall. Again, if they're following the statute, which is Florida Statute 985-565, and it pertains to juveniles prosecuted as adults, at the sentencing hearing, a pre-sentence investigation report should include a section prepared by the Department of Juvenile Justice with its recommendations as to disposition. For some reason, the Department of Juvenile Justice decided to do a staffing, which is not required under that statute, to do a staffing for Jessie Sutherland and give him the opportunity to present mitigation, but they did not give that same opportunity to Simeon Hall. Why do I point this out to the court? I point this out to the court because it's the state's position that we are attempting to seek justice in this case? And how can the court rely on these dispositional reports when both individuals are not treated exactly the same, when they are similarly situated when it comes to their prior record or lack thereof? Now, the fact of the matter is, if you go on and you look at the report, the recommendation from the Department of Juvenile Justice, in the recommendation on Jessie Sutherland, they refer to him as a youth. In the recommendation on Simeon Hall, they refer to him as a defendant. The correct term from the state's perspective, since they're in the adult system, is they are both defendants. So I question why they seem to be giving more leniency to the person who actually killed Roger Trindade. They are recommending a mid-level commitment for the individual who started the physical contact by pushing Rodrigo, who then killed Roger Trindade, and then spit on him, and then celebrated his knockout punch. Now, clearly, Simeon Hall was just as much involved, but he is not the one that physically killed Roger. He was a principal pursuant to the law, and so he is just as responsible for that death. So for all of those reasons, we are asking you to really give little regard to DJJ's representation, because it doesn't appear to be very accurate, especially given the mistakes that they made in their recommendations that I set out for the court a few minutes ago. Now let's talk about your second option. Your second option is to downward depart, again, if you have legal reasons to do so. So you could downward depart based on their age, based on this being their first criminal offense, and you could give them 5 years, you could give them 6 years, you could give them have that time followed by a lengthy period of probation. Unfortunately, with the youthful offender statute, you are limited. You have a limitation of a maximum of 6 years. And frankly, given what has happened, given their behavior in school, given Simeon Hall's actions after this incident, the second case, where he tampered with his ankle monitor and then battered another individual, given all of that, sanctions, and the legislature was very wise when they set those guidelines for this court. Now, I'd point out that in the pre-sentence investigation, the person who evaluated and prepared that recommendation, they recommended 10 years incarceration followed by probation for Simeon Hall, who didn't kill Roger. The other PSI recommendation is still incarceration on Jessie Sutherland, followed by probation. What I don't want this court, and I'm sure you will not, lose sight of is Roger. Roger was a 15-year-old boy in the IB program when he was killed. He was on the right path. He was raised by good people. He was in the IB program, even though he had a language barrier. He was extremely smart. He will never be able to finish high school. He will never be able to go to college. He will never be able to have a girlfriend or a fiance or get married or have children or have grandchildren. He will never be able to accomplish all the things he clearly could have. And as a result of that, he is dead because of the actions of these two defendants. Again, the state's position is The fair and just resolution is adult sanctions. Thank you.
Thank you, State. On behalf of Mr. Sutherland.
I'd like to start by reminding the court a mitigation packet was filed in this case a number of months ago, and we did hold plea conferences. That it has always been Mr. Sutherland's intent to resolve this case in a manner in which he was willing to take responsibility. You heard the emotional pleas of his father and his grandmother, who know him best. I did not recall them today, their testimony at the bond hearing and the plea conference in front of Your Honor. I'd just like to remind you of that. The juvenile probation officer who was responsible for monitoring Jessie also came to testify not once but twice, to testify that he was a good kid in the community while on electronic monitoring, and that he had no issues. I'd also like to remind the court again that Mr. Sutherland was originally willing to plead to the state's offer, which was given to us, I think, the Friday before trial finally, and that offer was revoked by the state when the co-defendant didn't accept that. Given my lack of experience in front of Your Honor, we decided not to blind plea, and we found ourselves in trial. We are here now. You heard all the facts. We're not relitigating the facts. What I'd like to do is highlight some of the findings from the comprehensive evaluations conducted by the Department of Juvenile Justice, Dr. Olander's report, and Mr. Sutherland's statement in the PSI. Ultimately, the Department of Juvenile Justice recommends a high-risk program. The state incorrectly, the state is wrong about the law. What the law actually says under 985.001 sub 5 sub A, juvenile jurisdiction for a child who's been transferred to adult court but sentenced to juvenile sanctions. Anytime a child is committed to the department, jurisdiction is retained until their 21st birthday. So Mr. Sutherland could be committed to the Department of Juvenile Justice, serve his sentence in a rehabilitative program, and then Your Honor would retain jurisdiction on conditional release until his 21st birthday, which would be a total at this point of almost 5 full years. When it comes to the recommendation by the Department of Juvenile Justice, though, they say a high-risk residential program is appropriate for Jessie. And in their May 22nd of this year comp eval, I just want to highlight youth on page 3. Youth takes responsibility for his actions. Youth has the ability to make positive changes in his life and stay committed to his goals and plans. On page 6, he is a high risk and significant risk for suicidal behavior, and then it goes on to state, based on his depression and anxiety, primarily a diagnosis of PTSD from this incident. Now, they didn't make an ultimate recommendation in the 2018 comp eval, but they go on to say that he has not received any additional charges, he was never in violation of any of the terms of his release, he had a strong, stable, committed family support system, he continues to engage in academic functioning, has no history of substance abuse, and is low risk to reoffend. In the 2017 comprehensive evaluation by DJJ, they did make a recommendation. And he will be further stabilized. He is in the care of his supportive family. Again, he is low risk to reoffend. We heard from Dr. Olander. Dr. Olander actually evaluated Jessie, and she gave her opinions primarily that placing Jessie in the Department of Corrections would subject him to the risk of deviant peer contagion. Essentially saying,
will you repeat that?
Deviant peer contagion. Putting this child in the Department of Corrections, it's my understanding that the youthful offender camp and classification generally is from the ages of 16 to 24, so quite a bit older than Jessie, could put him at risk to actually increase reoffending. That by putting him in this environment with people who do make bad decisions, who do display delinquent or deviant behavior, he will be at risk of, in his most formative years, becoming a young man, being exposed to only that bad behavior, and he could come out worse. Now, with Dr. Olander's final conclusion, this was in the mitigation packet that I submitted to Your Honor. It was her opinion that Jessie would benefit from the least restrictive treatment program. Investigation by Jessie gave a written statement, and I want to highlight the last thing that he said. Although I know my words are meaningless to you, I am sorry. But I want you to know that even if I had not been found guilty, I would not, nor will I ever forget Roger. Before Your Honor is a 16-year-old kid who has been deeply impacted by a split-second decision that day. He is not a bad kid. And if everyone's goal is to keep the community safe, which we heard from Chief Deal, who I'm certain is aware then that Mr. Sutherland has been residing in his community since last January without incident. And protecting society would mean allowing Jessie to become the most productive member of society that he can be. There were 2 children involved in this incident that sit before Your Honor, and they were both given the same opportunities out in the community. One of them took advantage of that opportunity to stay out, and the other is currently sitting in 33rd. The disparity, any disparity that Your Honor comes to in sentencing is because these cases are so totally different, and the paths that these 2 children chose to take are completely different. If you give Jessie the opportunity to remain in the community and receive treatment, he will do that. He has proven to you that he can, without incident. Additionally, Your Honor, if you feel that some form of incarceration is absolutely necessary, choose the form of incarceration that won't put the community at risk, that won't harm Jessie, and that will give him some rehabilitation, which is the focus of the juvenile system. We're asking for straight probation. And if Your Honor doesn't find that to be appropriate, we'd ask that you levy juvenile sanctions, retain jurisdiction until his 21st birthday, and allow him to get the treatment and therapy that he needs to re-enter society. Thank you.
Thank you. On behalf of Mr. Hall.
That when we were arguing on ways, you indicated that the issue of principle was a very close line. My client has talked with a psychologist, he's talked with me, he's talked with his mother about his remorsefulness for being involved in this. If he could do it over again, he wouldn't be involved in the situation at all. But unfortunately, he got involved in something trying to protect a friend of his. And there's a constant theme in some of this stuff in that when the dad was breaking into the house where he had been told not to come into before, and not even to come to the door without calling, he put himself on the other side of the door, and the dad busted the door in on him and started beating him. On this night, remember the evidence from trial, what happened was Mr. Gouda and the other gentleman were going around spraying people on Park Avenue, and when they did it to Mr. Trindade and the gentleman that was accompanying him, they ran off, and the victim and his friend followed them. While they were following him, Mr. Gould called another individual that's not even charged in the case and said, "I'm about to get jumped," and told him where he was going to get jumped. And he said that to the group. My client got on a bike solely to go down there and help his friend who he thought was getting jumped. Same thing with Mr. Sutherland. There was no discussion at all. There's no evidence that they had any discussion about that they had been spraying the poop spray, that they knew what they were up to. They knew each other, but they had parted ways quite a bit earlier in the afternoon or early evening. So, and the evidence at trial says that Mr. Sutherland threw the first aggressive blow and then stepped over and hit Mr. Trindade, and that one blow killed him. I'm sorry to the family. My client's sorry to the family. But you can't predict that. Of course, it happens from time to time, but one blow to a kid in a park on a grassy lot does not normally cause a death. So the aggression in this situation was started by Mr. Sutherland, and the death blow was delivered by Mr. Sutherland. Again, my client admits his involvement, and he would have entered a plea too, but we just couldn't, we didn't believe that I did not believe that my client should accept the same punishment that the state was offering for Mr. Sutherland, because they've now admitted that he's the sole person that caused the death, and he's the first person that even threw a blow. I agree with Ms. Had asked the probation officer if he and his mother could go places. Could they go to the movies? Could they go, anywhere out of the house other than doctors and grocery shopping? And they said he couldn't. And the mom actually conveyed that he was having a tough time staying in the house. Where did he learn how to take the monitor off? He was told that by somebody else in juvenile. And so he did take it off, and he went out that night and he got in a fight with a kid that he'd had a disturbance with before. But that doesn't change the perspective I believe that the court should be looking at when my client is not the person that delivered a blow to the victim. To give Mr. Sutherland a potential lower sentence than my client when my client's not directly responsible for the death. And I think the court at least acknowledged that to some extent when we were talking about the JOA. We acknowledge that Roger Trinidade's life's over, and there's nothing that can be done about that. And being a parent myself, I can't quite understand how these parents are surviving through this. And I think everybody that's a parent in this courtroom realizes that. I think both of our clients realize the depth of what has occurred. I don't think they understand it to the degree that we do, being parents. But I can tell you that my client wants to finish high school. He wants to be a productive member of society. He needs counseling, as the doctor suggested. He's not being treated for depression at all. He's being treated for anxiety, which his anxiety level has gone down some because of medication, but he's still very depressed. And she told you that if he was sentenced to an adult system, that his depression would only get worse. And we all know what happens in the adult system. Some people come out of it and don't ever get in trouble again, but for most, it's an education system for the wrong things. My client is 16 years old. When this happened, he was 14. And he spent approximately a year now incarcerated, and we've not moved to get him out. We thought that we could get him some help in the jail. They have given him medicine, but they've not counseled him much. And he deserves a chance to go on and try to develop his life. That's appropriate considering the fact that he did violate his terms of pretrial release, but we would like you to give him a middle or high level of useful offender. That will allow him to get some counseling. It will allow him to be in a structured environment, allow him to continue with his education, not just for a GED, continue in high school, and will give him the opportunity by the time he reaches 21 to come out and be productive. If he gets in trouble in that time after he gets out of the program, then the court's going to have an opportunity to address him again. But we think he will be on the right track, and he's assured the psychologist that he will do what he can to improve himself and come out and do the right.
Sentencing.
No, ma'am.
Mr. Hall, is there anything you wish to say prior to sentencing? I have listened to all the information in this case. First, let me say that clearly this is hard on everyone involved, and the idea of what's right in this decision, I'm not sure anyone could do what's right in this case. I don't think it's possible to do what's right in this case, and I think there's a lot of debate between what's best in this case. I think there's a lot of good, smart, intelligent people that debate what's best in a situation like this. I also want to say that the participants, that everyone I heard from in a very complicated, difficult case, did a fabulous job, that they brought information that was helpful and relevant and important, and very few times as and that's greatly appreciated, and as much as it can help reduce risk of mistakes, it certainly is, again, appreciated. I received all the information. I've listened to all the testimony. I've obviously been present in the case. I'm a member of the community. The courts, we're all here. The state of Florida, interestingly, as a statement, my understanding is one branch of the state of Florida is arguing heavily for punishment and as much punishment as possible. Another branch of the state of Florida, through the PSI, is asking for a whole different sanction. And another branch of government, through the Department of Juvenile Justice, is recommending a complete reports and the information and go under the guidelines, which is the guidelines, which is the punishment method of adult system, which is understandable. It's one of the hardest cases the community has to endure. A young life was taken, it was stolen. It was hard for Winter Park, the community. It was hard for everyone in a situation of thinking that your children can be safe when they go out at night in a place that we all believe is an incredibly safe. One could be removed enough to not know how great Roger was. I don't think anyone who lives in this community could not have heard how amazing that child was and how much he had done and how smart he was and what hope he had of all the great things he was going to do in this world. I think the kids at Winter Park High School were affected by it. I think the police officers, the testimony really makes it clear just how it struck to the core of fear in the community that at any time life can end. And I can't even imagine the pain to the parents or the ones that knew him well. I can't even imagine, and I'm sure none of us really can imagine that. As the dad said, though, we can't be here about after the punishment goal, if in fact we can get there. It's really clear under the statute. We're about punishment. And after if we can consider something else, then we should consider the safety of the community afterwards and the potential rehabilitation of the person who committed the crime. The juvenile system is exactly opposite. Our idea in the juvenile system is that children are not yet developed, that they do things that adults wouldn't do with motivations that adults can't understand. Sometimes no motivation at all, and we know that. I've heard the testimony of the doctors. The Department of Juvenile Justice wrote an extensive report along with analysis and psychological evaluations of the children. And their knowledge is about kids and about juveniles and about how society best takes children and turns them into good people doing things for society. And we all know the research shows that that's not done by just incarcerating people. It's just clear. Anything else is just not the truth. So looking at the children and the events here and looking instead to the information with these kids, we know we have two children. We have two children, one of which just entered 8th grade and one who had just entered 9th grade when this happened. That one of them punched one time and the other child died. That the other child helped that happen. That both acted awful afterwards, disrespectfully, like pack mentality of the way we don't want to see kids behave, and we don't want to see people behave. That both of them prior to this had never had any arrest or had any priors. That their maturity level under all the reports, and there doesn't sound to be dispute, and there's not any conflicting information from the state provided, that both of their maturity level was incredibly immature. And I don't say that as a insult. I say it as a scientific reality of they were both immature. Bodies can look full grown, but what's inside, again, as we know when we have children, sometimes how they look and how they are on the inside are completely different. And from all the analysis of these children, they were both immature. One with a very large one that has, under the reports, a 4th grade level, and he was further along in school. It showed intellectual processing ability at the level of intellectually disabled and what we used to call mentally retarded. That each of these children, like Roger, had supportive, loving families. They both had really good family support, loving families. And they have one of them with a very close bonded relationship with a father, another one with a close bonded relationship with his mother. but good families with no information that I've seen from anywhere showing these families did anything in a way that created it. Just like all the facts in the case, Roger didn't do anything to cause this. He didn't do anything to deserve this. And his parents didn't do anything or make any mistake or anything along the line to get close to deserving this loss. It's clear under the risk assessment, which is the highest scientific thing we have, that with all the factors, that the risk to the community is slight, the lowest level possible for Mr. Sutherland. The research shows on that the worst thing we can do when people have the lowest level to reoffend is bring them in our system. We tend to create criminals then. It's the worst thing to do. The research is clear on it again and again. So if we are caring about the safety of the community, if what we were to do is to send Mr. Sutherland to prison for as long as he could, he will get out, and we have now started a process of trying to create a criminal that isn't there yet. And right now, it's the lowest possible. What their intent was, what their motivation, the evidence came out at trial, as I heard it, that they thought they were helping a friend who said that he was getting ready to get jumped. It was foolish. It was silly. It was stupid. But it seemed that that's what they thought they were doing. That friend has been, my understanding, sentenced in juvenile, with juvenile sanctions. All of us are more than just our worst day. A kid who steals something, candy from a store, isn't a thief and isn't a thief forever. We're more than just what our worst action was. Knowing that, and knowing that all people are required to have hope, redemption, and certainly children. That's what we base it on. And understanding all that, the difference between the system, the difference between the adult system and the juvenile system is not which one's most minor. It's not even true. That's actually not true, because in this situation, a youthful offender, which is an adult sanction, could be probation or a fine and no supervision whatsoever. So it's not about which one's most minor. It's about the juvenile system is there to help children become productive adults with resources that they have, with evidence-based ways that we can do that in society. The adult system is there to punish. If one sentence, if one justice could inoculate children from having to face such fear of going out and getting hurt, if one sentence that I could make here could stop that, or somehow get people who are out there doing behavior like bullying or fighting, and it would stop it, it's an easy decision. You just sentence them to the max. If that just fixes society in that way, that would be great. But one sentence can't, and there's no power in that, and there's nothing that shows, and there's no evidence that shows that what we do here, and the evidence is exactly the opposite. It does not have deterrent effect. And it's not what our juvenile system's based on, and it's not what our adult system's based on. We don't ascribe to deterrence because we know it does not work as we do it in society. We know that. So although it might make everyone feel better, it's not what we do. And with that, after evaluating all the information and listening carefully, and the court, as well as all the people struggling with what is the best decision in this case, I am, in fact, going to impose juvenile sanctions. Now, my question at this point, I do know I'm not going to follow the staffing that was done. I do know that it was done at the end in a rushed manner, although I think that the information provided was really helpful, good information with a lot of tests. I think the last part of it was clearly rushed, being I got it after 5 o'clock last night. I know it was rushed, and not everyone had the opportunity to present everything they want. The school didn't have the opportunity to be there. They had the records from the school, but they didn't have all the information from the school. There wasn't the opportunity given that should be given. And that's true for Mr. Sutherland, where the state needs more opportunity for that staffing. It's also true for Mr. Hall, where clearly Mr. Hall should have an opportunity and his attorney should have an opportunity to present what they need for the staffing. So I'm going to order another staffing. And that's where we are at this point. And with that will the attorney's approach. I will at this time adjudicate delinquent, order the staffing. How much time do we need for the determination of what commitment level?
Your Honor, if I may, Kct Hammond on behalf of the Department of Juvenile Justice. I'm trying to make sure I'm getting near a microphone. Part of the concern I know from the state was getting victim impact statements. They had mentioned that to the department. I don't know how long it's going to take them to get that information together. And if both defense counsels wish to have the doctors' evaluations of their private evaluators taken into account at the case staffings, then they would need to obtain those. We don't have access to those at this point, but those doctors will testify here, but the person who would be conducting the case staffing was not here to hear that either. So that information would need to be gathered and provided. So I would say at least 2 weeks. It might be able to be done sooner if everything can be coordinated, but I'd ask for at least 2 weeks for that.
State, how much time do you need?
Not long.
Tell me what that means for you.
2 weeks is fine.
Defense, how much time do you need?
I can be ready next week, Judge.
On behalf of Mr. Hall, how much time do you need?
Your Honor, it's taking 2 weeks to do the staffing and do the report. I'd like a little bit more time than that. Maybe another week to get it prepared. Of course, if we get it done this week.
Understanding that, understanding all that, and also seeing what is on, what is happening in this court, we'll set it for the 16th, July 16th at 9 a.m. for the final, just determining what the juvenile sanctions are. I think you do. I think you do. Okay. And with that, anything further state?
I just want to clarify, July 16th, that's a Monday, that's when you will decide what juvenile sentence you will impose, is that correct? Or is that for the staffing?
No, the 16th is for the final juvenile disposition.
Thank you.
Defense, anything further?
Will my client remain with the family until the final disposition?
I'm not changing anything with commitment at this point.
Well, Judge, Florida statute, actually...
Will the attorney's approach?
Yes.
And with that, we'll be in recess. No. Hey. I'm not going to handle right now. Oh, I'm sorry.
I hope so. That was really nice. Please don't forget